Okay, let's dive in. Picture this. A courtroom decision, a conviction for a really serious crime, but the whole thing unravels. Not because of doubt about what happened, oh no. It unravels because of words, specifically words a judge didn't say.
That's right. It's a fascinating, almost unsettling example of how the precise machinery of the law works. Sometimes the outcome hinges on these very fine procedural points.
We're talking about a case where a conviction, based on evidence a jury found believable, got thrown out, all because a specific mandatory phrase meant to protect a young witness wasn't spoken exactly right by the judge.
It really underscores how procedure isn't just red tape. It's fundamental to justice.
Absolutely. So the case we're dissecting today is SHV Regina. It's a New South Wales Court of Criminal Appeal decision from 2012. The citation, if you're looking it up, is 2012 NSWCCA 79.
And it really reads like a legal procedural drama, doesn't it? Less about who did it and more about, how did the system operate here? Was the process followed correctly?
Exactly. Where did things go off the legal rails, so to speak? And the core issue involves the testimony of a very young girl.
An 8-year-old girl. She was the complainant in a case alleging sexual intercourse with a child under 10. A profoundly serious charge.
And her evidence was absolutely critical. Without it, the prosecution likely had no case.
Right. So the big question from the appeal court was this. How could a conviction relying so heavily on her testimony be invalid? Not because they doubted her story, but because of a procedural slip-up when she gave that evidence.
That's the puzzle. So today we're doing a deep dive into the sources of the court judgment itself, mainly, plus a summary blurb talking about its impact. We'll unpack it all.
Step by step, we'll look at the key players, the specific law involved, what happened, and crucially, what didn't happen at the trial.
Then we'll follow the arguments up to the Court of Criminal Appeals, see how the judges reasoned it out, and finally, understand how this one case actually changed legal practice in Australia, especially around vulnerable witnesses.
It's like assembling the cast of this legal drama. You've got the accused, known only as SH. You've got the young complainant, central to everything.
Then the trial judge, King DCJ, and the 3 appellate judges who made the final call, Baston J.A., Blanche J., and Hall J.
And we'll see how their words, and critically, the trial judge's lack of certain words, became the pivot point.
All right, let's set the scene. The trial itself. Where and when did this first act play out?
We're in the District Court of New South Wales. The case number was DC 2008-17999. The trial judge, Judge King DCJ, handed down the verdict on January 21st, 2011.
And the charge, again, just to be clear.
Sexual intercourse with a girl aged under 10 years. The stakes couldn't really be higher.
And the prosecution's case rested heavily on this 8-year-old girl's testimony.
Absolutely essential. Without her account, the case likely collapses.
Now, because she was so young, how she gave evidence was important. She didn't give sworn evidence, right? No oath or affirmation.
That's correct. She gave unsworn evidence, which is quite common and necessary for witnesses, especially children, who might not fully grasp what an oath means, that formal obligation to tell the truth.
So the law allows for that.
Yes. The Evidence Act 1995 in New South Wales specifically caters for this. Section 21 generally requires an oath or affirmation, but it points to Section 13 for exceptions, like unsworn evidence.
Okay, Section 13. This seems to be the critical piece of legislation here. What's it all about?
Section 13 deals with witness competence. Basically, is this person legally capable of giving evidence in court? It's got layers.
Layers. How so?
Well, subsections 1 and 2 set out the basic test. Can the person understand questions about a fact? Can they give answers that make sense? Most people, including children who can communicate, will usually meet this basic standard for giving some kind of evidence.
But that doesn't automatically mean they can swear an oath.
No, that's Section 13.3. To give sworn evidence, a person needs the capacity to understand they are under an obligation to give truthful evidence. It's more than just knowing truth from lies. It's understanding that solemn duty in a court setting. Many young kids might not grasp that abstract concept.
Right. So if a child understands questions and can answer, but doesn't quite get the obligation part for sworn evidence, what happens?
Then they might still be able to give unsworn evidence. And that's where Section 13.4 comes in. It says someone not competent for sworn evidence may, and this is key, subject to subsection 5, be competent to give unsworn evidence.
Subject to subsection 5. That sounds important.
It's absolutely crucial. It leads us right to the heart of the SHV Regina appeal, Section 13, subsection 5.
Okay, lay it out for us. What does Section 13.5 demand?
This subsection dictates what the court, meaning the judge, must tell the person before they give unsworn evidence. It's very specific. Three things.
Three things the judge has to say. What are they?
First, paragraph A. The judge has to tell them that it is important to tell the truth. Simple enough.
Okay, number 1, tell the truth. What's next?
Second, paragraph B. Tell them that he or she may be asked questions that he or she does not know or cannot remember the answer to, and that he or she should tell the court if this occurs. Basically, it's okay to say, I don't know or I can't remember.
Right, manages expectations, don't guess. And the third one, this must be the big one.
It is, paragraph C. The judge must tell the person that he or she may be asked questions that suggest certain statements are true or untrue, and that he or she should agree with the statements that he or she believes are true.
Oh.
And a she should feel no pressure to agree with statements that he or she believes are untrue.
Ah, okay. Should feel no pressure to agree with statements that he or she believes are untrue. That sounds like a really vital safeguard. Why is that specific bit so important for a child witness?
It's fundamental. Think about a courtroom. It's intimidating for anyone, let alone a child. You've got lawyers asking potentially confusing questions, a judge in robes, authority figures everywhere.
Yeah, I can see that.
There's a natural human tendency, especially for children facing adults in authority, to, well, want to please or to avoid conflict. They might just agree with what an adult suggests, even if it's not right.
It's like being suggestible under pressure.
Exactly. The judgment even mentions principles from older cases like Anunga, which dealt with indigenous witnesses potentially feeling obligated to agree with authority figures. The same vulnerability applies to children. They might not get the whole adversarial thing, lawyers trying to poke holes in their story. They can feel pressured, even unintentionally, to just go along with suggestions.
So Section 13.5c is designed to counteract that.
Precisely. It's the law explicitly saying to the child, hey, it's okay to disagree. If a lawyer or even the judge suggests something you know is wrong, you must say so. Don't feel pressured to agree just because they're a grown-up asking the questions.
It empowers them to stick to their truth, even when challenged by authority.
That's the intention. And there was a key change to the law back in 2007, before this case, that makes this even more pointed.
Well, what changed?
Before 2007, the old Section 13 required the judge not just to give the instruction, but also to check if the child understood it and got a sort of promise back that they'd tell the truth. The judge had to assess their response.
Okay.
The 2007 amendment got rid of that response requirement for SA's 13.5. Now, the law only requires the judge to give the instruction. The focus shifted entirely onto the judge getting the words right. The child's understanding or response isn't the legal test anymore for this part.
Wow, okay, so the onus is purely on the judge to deliver the script perfectly.
Exactly, which makes strict compliance with the exact wording of S13 paramount. And this ties into the core legal argument that won the appeal.
Which was?
That complying with S13.5 isn't just good practice or something affecting admissibility. It's a condition of competence. Remember,
Well,
S13.4, competence subject to subsection 5, and S13.5 is competent if these things are said.
so if the judge doesn't say the magic words?
Then, legally speaking, the witness is not competent to give unsworn evidence. Full stop. Their testimony is inadmissible right from the start.
Okay, the legal battleground is clear. Let's go back to the trial itself. How did it actually play out?
Right. So the trial starts. Jury empaneled, prosecution and defense give their opening statements. This was April 20th and 21st, 2009.
And then, before the jury hears from the child?
They hold a competence hearing. Standard procedure. The jury leaves the room. The child appears via closed-circuit television or CTV, which is often used to make it less stressful for young witnesses.
And the judge, King DCJ, starts questioning the child.
Yes, he asks her questions, trying to figure out if she understands the difference between truth and lies, exploring if she meets the standard for sworn evidence, understanding that obligation to be truthful.
What were the lawyers doing during this?
Well, the prosecutor suggested, perhaps optimistically, that the child could make an affirmation, meaning give sworn evidence. But the defense counsel representing SH raised doubts, pointing out difficulties the child seemed to be having with the concepts.
Did the judge acknowledge the need for the unsworn evidence instructions if she didn't qualify for sworn?
He did. The judgment quotes him saying he'd need to deal with the matters that arise under Section 13, subsection 5, if she was going to give unsworn evidence. So it's definitely on his radar at that point.
Okay. The hearing continues.
Yes. More questions, including from the prosecutor. The judge still expressed some reservations about her overall capacity, but he allowed the prosecutor to keep questioning her to help the assessment.
And this is where the prosecutor asks those questions about pressure and agreeing with grown-ups.
That's right. Quoted at paragraph 28 in the judgment. The prosecutor asks things like, if he says to you something that's wrong, are you going to agree with him? Child says no. Do you understand that it's important to tell us if you don't agree with us? Yes. Do you understand that you shouldn't feel under any pressure because we are grown-ups in funny clothes to agree with us if we're not right? Yes.
Sounds like the prosecutor is trying to cover the ground of S135C.
Trying to, yes. Addressing the ideas behind it. But then came a really critical exchange.
What was that?
The prosecutor asked, do you know what that means to be under pressure? And the child answered quite clearly no.
She didn't understand the word pressure.
Exactly. Even though the prosecutor tried to explain it further, about not agreeing just because their grown-ups are grumpy, and she eventually said yes. That initial no really flagged an issue with her understanding of a key concept in the mandatory instruction.
Did the defense lawyer react to this?
Yes. The judgment quotes SH's counsel at 31 speaking directly to the judge. He expressed concern about her difficulty answering the judge's questions earlier, and while acknowledging the prosecutor's efforts, stressed that Section 13 is quite specific about confidence for unsworn evidence, essentially putting the judge on notice. Your Honor, are we sure these specific requirements are met?
So what did the judge decide after all this?
He gave a brief ruling on competence, quoted at 33. He found her competent to give unsworn evidence, and crucially, he stated she had effectively been told of paragraphs A, B, and C of subsection 5.
Effectively been told? He thought the job was done.
It seems so. He believed the combination of his earlier questions and the prosecutor's questioning had covered the necessary ground. However, the appeal court later pointed out something interesting at 34.
It's that.
That at this stage, defense counsel could have made a specific objection. Your Honor, you haven't actually given the S13 instructions yourself yet, as required before the jury hears evidence. But that specific objection wasn't made right then.
Okay, so the judge finds her competent for unsworn evidence. What happens next?
This is the moment where the crucial error occurs. The jury is brought back in. The child is back on the CTV screen, ready to tell her story to the people who will decide the verdict.
And the judge addresses her again.
Yes, presumably to give those formal S13-5 instructions directly on the record before her evidence begins. The judgment quotes the exchange at 35 and 36.
Let's go through it. Did he cover point A, telling the truth?
Yes, Judge. Do you understand that it's important that in telling us about what happened, that you tell us the truth, child? Yes. So check for A.
What about B, saying, I don't know, or I can't remember?
Cover that too. Judge, you understand that if you're asked questions and you don't know the answer, you should say that you don't know. Child, yes. Judge, do you understand that if you're asked a question and you can't remember the answer, you should say that you cannot remember? Child, yes. So check for B.
Okay, now for the big one. C, suggestions and pressure. What did he say?
Right. Quoting from 36, the judge asked, now, do you also understand that if someone suggests to you that something is untrue when you say that it's true, that you should tell us that what they've said to you is wrong? Child.
Yes.
So he asked if she should point out if a suggestion was wrong. That sounds like part of C.
It is part of C. It covers the first limb, agreeing with true statements and disagreeing with untrue ones. But, as the appeal court stressed at 37, he missed the second, equally mandatory limb.
Which was?
He failed to add the crucial phrase that the witness should feel no pressure to agree with statements she believes are untrue.
He left out the feel no pressure bit entirely. That was it. The fatal omission. The appeal court was adamant. The law requires the judge to give the instructions from S13-5 in full, not just part of them.
But hang on, didn't the prosecutor's questions earlier touch on pressure? Didn't the judge think he had effectively covered it?
The appeal court acknowledged the prosecutor's questions at 38. They even said it was hard to see that this specific omission alone caused a substantial miscarriage of justice in the sense of changing the outcome. But TT, and this is the absolute crunch point, they rejected the idea that the prosecutor's earlier chat could substitute for the judge's mandatory, complete instruction given at the right time just before the jury heard the evidence.
Why couldn't the prosecutor's earlier questions fix it? It seems like the idea was floated.
Because the statute, Section 13-5, puts the obligation on the court, the judge, not the prosecutor, and it requires the instruction before the evidence is given. Allowing bits and pieces from earlier or from someone else to patch up the judge's omission would completely undermine the mandatory nature of the rule. It would create uncertainty. The court needed clarity. The judge must say the whole thing, as written in the act, at the legally required moment.
No substitutions allowed.
No, they were very clear on that at 39. The instruction has to come from the bench, completely and accurately.
So, leaving out "should feel no pressure to agree" meant the judge failed to comply with S13-5.
Correct. And since compliance with S13-5 is a condition of competence.
The child was legally not competent to give unsworn evidence. Her testimony shouldn't have been admitted.
Exactly. Despite everything, despite the jury hearing it and believing it, legally, it was inadmissible from the outset because the gateway wasn't properly opened.
And that procedural failure, that missing phrase, became the basis for SH's appeal against his conviction.
That's right. He took his case to the New South Wales Court of Criminal Appeal, the CCA.
Which judges heard the appeal?
It was a panel of 3, Justice Baston, Justice Blanche, and Justice Hall.
And who are the lawyers arguing this complex point? We should name the legal teams.
A good point. Arguing for the appellant, SH, was counsel D.L. Carroll, instructed by legal aid NSW. And representing the Crown, the respondent, was counsel N.F. Noman, instructed by S. Kavanaugh from the Office of the Solicitor for Public Prosecutions.
So counsel Carroll's main argument for SH was, the judge messed up S13-5. That means the witness wasn't competent, her evidence was inadmissible, so the conviction must fall. Even if no one objected perfectly at trial, even if it didn't seem to change the outcome.
That was the core submission, and it forced the CCA to really drill down into that critical legal distinction we touched on earlier.
Competence versus admissibility. Let's unpack that properly. Why is this difference so vital?
Okay, think of it like this. Admissibility rules often deal with how evidence is presented or whether it's fair to use it. Maybe evidence was obtained improperly or it's overly prejudicial. If a rule of admissibility is broken, sometimes it can be waived if the other side doesn't object.
Right.
And even if wrongly admitted evidence gets in, an appeal court might say, okay, that was an error, but honestly it didn't make a real difference to the fairness of the trial or the outcome. They could apply something called a proviso and let the conviction stand if there was no substantial miscarriage of justice.
So admissibility errors might be fixable on appeal. What about competence?
Competence is different. It's more fundamental. It's about whether the person has the basic legal capacity to be a witness at all in that specific way, like giving unsworn evidence. If the rules for competence aren't met, the person legally cannot give that evidence. It's not just flawed, it's a nullity.
It's like they weren't even allowed to speak, legally speaking.
In that specific capacity, yes. The appeal court cited a Victorian case, the Queen v. W.G., which made this point strongly. Failure to meet competence conditions like those in S13 isn't just an error. It results in a miscarriage of justice that cannot be saved by the proviso. The trial simply wasn't conducted according to law.
Because every accused person has the right to a trial conducted lawfully.
Exactly. Receiving crucial evidence from someone who wasn't legally competent under the statute fundamentally undermines that right. It's a structural flaw in the trial process itself. The conviction has to be overturned, regardless of how convincing the evidence might have seemed.
And the CCA judges in SH v. Regina definitively classified Section 13-5 as a condition of competence.
They did. They pointed to the specific language, subject to subsection 5 in S13-4, and is competent if in S13-5. They said this wording makes delivering that full instruction mandatory. No instruction, no competence. Simple as that.
Were there previous cases guiding them on this?
Yes. They didn't make this decision in a vacuum. They looked at earlier NSW cases like R.V. Brooks, which dealt with the old version of the law but still stressed the need for strict compliance. They noted how the 2007 law change actually strengthened the focus on the judge's duty to give the instruction.
Did they look outside NSW?
They did. They found support in cases from other states with similar laws. A Queensland case, R.V. BBR, found that failing to give a similar explanation to a child vitiated the trial process, invalidated it.
Vitiated. Strong word.
Very. And a South Australian case, R.V. Starrett, was particularly influential. It found the failure to give the required instruction was a fundamental irregularity causing a miscarriage of justice. The Starrett court said plainly the trial was not conducted according to law.
So a clear line of authority saying these instructions are non-negotiable pillars of a lawful trial for unsworn evidence.
Precisely. The CCA and SH v. Regina felt the reasoning in Starrett and WG strongly supported their conclusion. The failure to follow S13-5 strictly meant the appeal had to succeed.
What about the lack of objection from the defense at the exact moment, or the fact the prosecutor had touched on pressure? Did the Crown try to argue those points?
Oh yes, the Crown, the respondent, argued those points. They likely suggested the omission was minor, didn't cause actual prejudice, and wasn't properly objected to. But the CCA rejected these arguments
Why?
because the issue was competence. Once they determined DRESEC 13.5 was a condition of competence, the failure to comply was fatal, irrespective of objection or perceived lack of prejudice. The prosecutor's earlier questioning couldn't cure the judge's statutory duty. The lack of a specific objection at the final moment couldn't waive a fundamental condition for the witness's legal capacity to testify.
So the logic was, the judge missed a mandatory competence step. The witness was not legally competent. Her evidence was inadmissible. The trial relying on that evidence was unlawful. Conviction overturned.
That's the chain of reasoning, exactly. The court's conclusion at 39 was stark. The complainant was not competent to give unsworn evidence because she was not given the directions required by S 13.5 in full. Therefore, the trial was flawed.
So the final decision from Justices Baston, Blanch, and Hall.
Appeal allowed. Conviction quashed. Set aside.
Wow. Conviction for such a serious offense overturned based entirely on the omission of that single phrase about pressure?
It's a stark outcome.
Yeah.
And the impact was immediate and pretty significant within the legal profession. The summary blurb wasn't exaggerating when it said it set a new standard and sent shockwaves through the legal system.
Shockwaves? Really? From one case about one phrase? How?
Because it was such a clear, high-level ruling on a common procedure. It drove home, very forcefully, that the Evidence Act's requirements, especially for vulnerable witnesses, are not just guidelines. They are strict, mandatory rules. Get them wrong, even slightly, and the evidence is out. Potentially, the whole case collapses.
So courts had to react?
Instantly. The blurb says they scrambled to adjust. What that means practically is judges had to become incredibly careful about delivering those S 13.5 instructions. No more paraphrasing or assuming concepts were covered.
They had to stick to the script?
Exactly. The blurb mentions judges' carefully rehearsed instructions. You can bet checklists and standard scripts became even more common in courtrooms across Australia to ensure every single part of S 13.5 A, B, and C, including the no pressure bit, was read out verbatim. Court staff, associates, everyone became hyper-aware.
And what about the lawyers? How did it change things for them?
Well, for defense lawyers, SHV Regina became a very important precedent. It gave them a clear, strong point to argue on appeal if they spotted any deviation from the S 13.5 script by the judge. It meant listening intently during competence hearings and right before the witness testified.
A potential way to challenge a conviction based purely on procedure.
Yes. It reinforced that meticulous attention to procedure isn't just pedantry, it's fundamental. It's about ensuring the trial adheres to the law. Prosecutors, too, would have become more vigilant in ensuring the judge conducted this step correctly to avoid appeals.
So the legacy of SHV Regina is really about the absolute need for strict procedural compliance, especially with rules designed to protect vulnerable people and ensure the integrity of evidence.
That's the core takeaway.
Yeah.
It hammered home that a trial must be conducted according to law, and that includes getting these statutory gateways like S 13.5. Exactly right. It's a safeguard.
It does create that tension, though, doesn't it? A conviction overturned despite a jury believing the evidence because of a procedural point. It wasn't about the truth of the allegation anymore.
It wasn't. It was purely about whether the legal process for admitting the unsworn testimony was correctly followed. The court found it wasn't. End of story for that conviction.
So why should you, listening now, care about this level of procedural detail, these missing words?
Because these rules, these procedures, are what guarantee fairness and reliability in the system for everyone. Even if the outcome in one specific case feels unsatisfying or technical, upholding these rules protects the integrity of the whole process. Rules like S 13.5c exist for a reason to shield vulnerable people, to ensure evidence isn't tainted by pressure or misunderstanding, to make sure the state follows its own laws when prosecuting citizens.
It's about the bigger picture of justice being administered lawfully.
Precisely. If we start letting procedural safeguards slide, even seemingly small ones, where does it stop? Strict adherence is a cornerstone of the rule of law.
So SHV Regina is a powerful reminder. In law, words matter immensely. And sometimes, yeah, the words that aren't said can change everything.
Absolutely. It cemented the principle of strict compliance for witness competence rules, especially for the vulnerable. It set a clear standard that courts and lawyers across Australia had to follow.
Which leaves us with a final thought, something for you to chew on. When the system insists on such rigorous procedural fairness, even down to specific words, that it sometimes overturns convictions based on seemingly credible evidence, does that unwavering focus on process always serve the ultimate goal of finding the truth? How do we balance that absolute need for trials conducted by the book with the equally vital need to hear crucial evidence and achieve justice, particularly when vulnerable people are involved?
That's the constant balancing act, isn't it? There are no easy answers.